protecting the game? The Protection of Sovereignty Bill 2026 presents itself as a bold assertion of national independence, yet beneath its language of protection lies a far more intricate and troubling legal architecture, one that may not only regulate foreign influence, but also entangle the Ugandan state in its own rules. In attempting to control how money flows into Uganda, the bill creates a paradox. It could expose the government itself to the very legal scrutiny it seeks to impose on others. A law that can turn on its creator. At the center of this paradox is Clause 24, which classifies all foreign funding to government institutions as public funds. And on open paper, this appears to enhance transparency. In practice, it opens a legal doorway. If donors' funds are legally treated as public resources, then their use becomes subject to public accountability standards. Should funds earmarked for health care, for instance, be redirected elsewhere, citizens or civil society actors could challenge the government in court for mismanagement and win successfully. Ironically, a law designed to shield sovereignty may provide citizens with new tools to question how that sovereignty is exercised. This is not a minor technicality, it's a structural contradiction. When foreign interference becomes a two-way street, the bill's provisions on disruptive funding deepen the contradiction. By criminalizing financial flows that influence political processes, the law adopts a strict view. Money tied to conditions equals interference. But this logic does not stop at NGOs or opposition groups. Much of Uganda's external financing, especially budget support, comes with governance or human rights expectations. Under a strict reading, such funding could itself be interpreted as shaping domestic policy. This creates an unusual legal possibility. The same framework used to restrict opposition financing could be invoked to challenge government loans or grants. What begins as a tool of control risks becoming a mirror. The problem of unequal rules. Perhaps the most contentious issue is not what the bill prohibits, but whom it exempts. While NGOs, individuals, and political actors must seek approval for foreign funding above a fixed threshold, the executive branch operates outside this constraint. The Ministers of Internal Affairs, who enforces the law, is effectively positioned to oversee others while remaining beyond equivalent scrutiny. This imbalance raises serious constitutional questions. Under Article 21, which guarantees equality before the law, critics argue that such selective application creates a double standard. One rule for citizens, another for the state. In legal terms, that asymmetry is difficult to justify. In political terms, it is even harder to defend. Legal rights versus practical reality. Although the bill theoretically enables legal challenges, even against the government, its structure simultaneously discourages them. The Minister of Internal Affairs holds sweeping discretion to define what constitutes sovereign interest or foreign interference. Courts, particularly in matters framed as national security, may differ to that judgment. More significantly, the risk of challenging the state are steep. Actions interpreted as obstructing government policy could carry penalties as severe as 20 years in prison. The result is a chilling effect, a law that allows challenges in theory but deters them in practice. The philosophy behind the bill. Money as power. To understand the bill, one must understand its underlying philosophy. What might be called financial sovereignty, at its core, is a simple but powerful assumption. Money is never neutral. The government's position reflects a belief that financial support from external actors comes with implicit obligations. Funding, in this view, is a mechanism of influence, a way to shape political narratives, public opinion, and even state policy. By controlling financial flows, the state seeks to control outcomes. This logic extends further. Opposition movements are seen not just as political entities, but as logistical systems powered by funding. Restrict the flow of money, and you restrict the capacity to mobilize. In this framework, finance becomes the fuel of dissent, and regulation becomes a form of containment. From economics to information control, the bill's concept of economic sabotage reveals how far this philosophy stretches. It treats not only money but also information as a strategic asset. Negative economic reports, especially those backed by foreign funding, are framed as potential threats. The reasoning is straightforward. Unfavorable data can influence investor confidence, currency stability, and international perception. In that sense, information itself becomes a financial instrument. By criminalizing certain forms of economic critique, the bill blurs the line between protecting the economy and controlling the narrative about it. Reclaiming the state's role. Another dimension of the bill is its attempt to reassert state authority over service delivery. For decades, NGOs have played a significant role in sectors like health, education, and water. The bill seeks to reverse that dynamics by requiring higher-level approval for foreign-funded projects. The intention is clear: to ensure that citizens associate essential services with the state, not external actors. This is not merely administrative, it is political. Control over service delivery translates into control over public loyalty. Minister has the system. If the bill has a single defining feature, it is the concentration of power in the office of the Minister of Internal Affairs. Approval of funding, interpretation of influence, enforcement of compliance all hinge on ministerial discretion. There are no strict timelines, no automatic approvals, and limited avenues for appeal. In effect, the predictability of the law is replaced by the judgment of a single office. This creates what critics describe as a system of selective strangulation, where organizations can be quietly immobilized through inaction rather than overt prohibition. The broader consequences, a climate of uncertainty. For local leaders, NGOs, and even businesses, this level of control introduces a new calculus. Partnerships with international donors, once routine, become legally and politically sensitive. Every grant, every collaboration, every report carries potential risk. The likely outcome is caution. Leaders may avoid international engagement, not because it lacks value, but because it carries uncertainty. Over time, this could isolate sectors that depend on global cooperation, from research institutions to development programs. In a simple term, sovereignty at a crossroads. The protection of Sovereignty Bill 2026 is more than a legal instrument. It's a statement about how power should be organized and exercised. It asserts that controlling money is essential to controlling the state. Yet in doing so, it creates contradictions that could challenge that very control. By redefining foreign funds, expanding executive authority, and narrowing the space for dissent, the bill reshapes the relationship between the state, its citizens, and the outside world. Whether it ultimately strengthens sovereignty or concentrates power will depend on not just on how it is written, but on how it is applied and who dares to test its limit.